News Radio 700 WLW.
We were just talking about it a minute ago with all these. I mean, and literally, this is frivolous stuff. Come on.
It seems like, and so in this case, there was a diner, and this is against a restaurant called Coup de Thai in Los Gatos. This woman, I believe, was having a dish at the restaurant known as Dragon Balls, okay? And it was a spicy dish. And they claim that it wasn't just spicy, but like to the point of excruciating. So she's now filed a lawsuit over the fact that the food was too spicy. And as we talked about before the break, it kind of harkens back to the 1994 case, Liebeck versus McDonald's, where she spilled a cup of coffee on her lap, had second or third degree burns, was in the hospital for a while, tried to get McDonald's to pay for the bills. They said no, took them to court, and wound up winning like $3 million or something. So, but this seems a little bit catty, but we shall see.
And we also, well, let's get our guest in here. Lin McCraw, he is a trial attorney from Texas, a former past president of the Texas Trial Lawyers Association, and on and on and on. Lin, welcome to the program.
Well, thank you for having me, sir.
So Lin, you heard us talking there, and the latest one today, I don't know if you saw this case or not, was some fella is suing Taco Bell because his burrito didn't have the representative amount of meat and beans, say, that he saw in the ad. Now, how much, are these things valid at all?
Well, having the amount of cheese and meat on a burrito, that is absolutely invalid. There's no way for an employer, for a person putting one of those together to get that absolutely right every single time. I don't think that goes anywhere. The other claim could be a little more interesting because you mentioned the word frivolous, and frivolous has a legal definition. You've got to have no basis in fact or in law. Well, I read up on that case just because I thought it sounded a little weird too, and the pleadings indicate, now this is if the lawyers to be believed, that the food was not just hot, that it was not just spicy, that it burned the lady's vocal cords. And I don't know if that's the truth or not. And that's why we have trials. That's why there might be a basis in fact for this case. But when there's no basis in law or in fact, the attorneys can be punished for that. And we've seen that recently with some of these political lawsuits in which lawyers get out over their skis and file stuff without any basis in fact. And the next thing you know, they're being disbarred.
Right. So, I mean, how would a case like this go? Would they take some of this food, and do they have those scales of hotness that are out there? Yeah. Do you bring that in and drop some in there and test it? How's it go?
What's going to happen, it will be like any other case. You're going to gather evidence. Now, part of the evidence is going to be taking depositions, taking the deposition of perhaps the cook to find out how much, stuff was put in there and what, for that particular deal. You're also going to have to look at what actually happened to determine if that person's telling the truth. When you have, there's a far cry between something being too hot and something that permanently damages somebody's vocal cords, if that indeed did happen. That's the reason that the case is being brought. I don't have enough evidence to know if that's frivolous or not yet, and that's why we have the Seventh Amendment that will allow us to take these to juries, so regular old people just like you and me can look at this and say, does this make sense or not? That's why we have the Seventh Amendment. That's why we have the right to trial by jury.
And what about, though, personal responsibility? And we're talking to Lin McCraw.
Yes, personal responsibility plays a big role. That's one of the reasons that some of the evidence that the jury will hear will be, what was advertised about these Dragon Balls, what warnings were given, how hot was it supposed to be, and what degree of harm could they have caused. Okay, if they can cause a great degree of harm, then you've got a duty to tell more about it, to let people know so that they're using if they know they're going to use a product that's going to cause them harm, they don't necessarily have a lawsuit if that harm has been disclosed. That's why people can still smoke cigarettes. That's why people can still use tobacco. We know it's harmful. If it's disclosed, then people can still use it, but it's got to be properly disclosed if it indeed causes that kind of harm.
The problem is everything is subjective, especially when it comes to food and temp and what's hot or not. What I think, I think eating a blazing wing at BW3 is awful. Wouldn't do it, but some people are like, oh, I can eat like 10 of those. It's no big deal. So that makes it hard to give a comparison and a contrast in a court.
It does make it hard, but it doesn't make it impossible. And to do that, you again go to the degree of harm that was actually caused. Now, if they find out when they get into this lawsuit that the lawyer embellished the damages, and if the person really didn't suffer significant injuries and that sort of thing, then I suspect the jury will do the right thing and toss it out. If, on the other hand, the person has lifelong injuries from this, then you go to the second phase and say, okay, what was disclosed? What was disclosed about this? What, is this something that had they had this happen before? Had they had other injuries, other people hurt from this? Those are the things that the jury would then weigh in making a decision. And, you guys mentioned the McDonald's case, the 1994 case, and I was picking juries, and there was a long time there that you couldn't pick a jury without people bringing up the McDonald's case. I happen to know the lawyer that was involved in that case.
Oh, wow.
And it was interesting because I didn't know all the facts until I talked to the lawyer. And when I talked to the lawyer, I learned that all he was after was he was just trying to get her out of pockets.
Yeah, like 20 grand in medical bills paid for, and that was
exactly.
it.
Exactly. That's all he was trying to get was 20 grand in medical bills. And for a situation in which she ended up having to have multiple surgeries in her private areas from third-degree burns that were lifelong problems. It's one of those situations that it's easy to say something's frivolous until we know all the facts and circumstances. Now, I, for one, put my faith not in politicians and not in rules that people put together, but in our juries. Both, the Sixth Amendment and criminal issues and the Seventh Amendment and civil issues give us the right to trial by jury. And that jury right is one of the reasons that we can have a full viewing of all these facts to figure out, okay, what is acceptable in our society in this community? And that's what I'm sure will happen here.
It's funny, in researching this, I was looking back through that, like Liebeck versus McDonald's, and I agree with you. I remember at the time thinking, oh, my God.
Right. Coffee's hot. Guess what?
But, supposedly they looked into it. McDonald's brews their coffee, at least at the time, at between 180 and upwards of 190 degrees, which is, then that can actually cause, almost boiling. So, then when you look at it and say, all that she wanted was just pay the measly 20 grand in medical bills, they said no. And then I think the lawyer said, well, how about 100,000? No. How about that? Kept like, I'm going to give you a chance before this goes to trial because we think we got a strong case. It went to trial and she was awarded $2.7 million.
Wow. I was going to say what it finally ended up settling out at.
Yeah. So,
well, all I can tell you about that case, that particular case, is after all the appeals and after it was reduced on appeal and measured by the judges and that sort of thing, I know the lawyer ended up losing money on the case in the end.
Really?
So it was not a financial windfall for him, for sure.
How would that
lawyers usually always get paid?
No kidding.
Lynn, come on.
Getting paid is one thing, but you got to understand the cost of taking something through the appellate process and through a jury trial is expensive. It's not cheap at all, and particularly once you start getting into the appeals and paying for the records and that sort of thing, it just it can balloon up on you in a hurry.
All right, with that, Lynn, that's fascinating
Very
stuff.
good stuff.
Really appreciate you talking to us.
Well, I enjoyed having you guys. Thank you for having me. I'm sorry.
Yep.
Our pleasure. Thank you.
Thanks, Lynn.
Lin McCraw. He's a trial attorney.